nature so we can get those resolved before we get too deeply into it. In that case, we'll proceed with this case.
Jefferson County, Tennessee versus Wilmoth Family Properties LLC et al.
Thank you. And may it please the court, I'm Clinton Little on behalf of the appellant, Jefferson County, Tennessee.
Mr. Little, you have reserved 5 minutes for rebuttal.
Yes.
Is that correct? Okay.
Yes, Your Honor.
Go right ahead then.
Thank you. Your Honors, this case began, we'll say in 2004. The defendants, Sean Wilmoth and Priscilla Wilmoth, purchased a piece of residential property in Jefferson County, and about 31.5 acres. And on this property was their residence. There was a pond and some other things. It's a pretty place. In about 2010, 2011, the first building other than the residence was constructed on the property that Mr. Wilmoth moved an eBay business into. Mr. Wilmoth is a bit of an entrepreneur, has several businesses, and so he moved an eBay reselling business into this building. At some point after that, the Wilmoths continued to develop this property and built different structures, all of which are used for renting as a venue to the public. So if you were to go online and go to Cedar Pond Farms website, which is the name that the Wilmoths operate this public event venue under, you'll find that it's advertised as a wedding venue. It's advertised as a public event venue for fraternity parties, sorority parties, retirement parties, political rallies, all kinds of different things.
Is this all part of the record, what's on the website?
Yes, Your Honor. The website as it existed at the time we filed suit was reproduced and was attached to the complaint. As for whether it's changed any or not since then, I'm not sure, Your Honor, and it's certainly not in the record after that. And so that's when the problems began. The Cedar Pond Farms, we'll call it, has approximately 400 parking spaces. It's plenty big, and seating for several hundred folks. And obviously, being in a residential area, the neighbors started to get a little upset, and the county began to become involved. Now, there's no dispute in this case that the activities taking place on the property violate the zoning ordinances of Jefferson County. The property zoned R1 or residential 1, and so there's no dispute there. The dispute is over whether there's some statutory exception to the zoning ordinance that allows these activities to continue. The trial was over whether or not, number one, Cedar Pond Farms is a commercial farm as required by statute, and then as to whether the activities of this commercial event venue business, if you will, is agricultural by definition after that. Admittedly, if it's agriculture, then Tennessee law does prohibit a county from regulating agricultural activities. That's where the dispute lies. So agriculture is defined, again, by statute as either recreation, education, or entertainment activities that are being conducted in conjunction with, but secondary to, commercial farming. The first question out of the gate is, what's commercial farming. That's not defined by statute. We argue that commercial farming is something other than hobby farming, personal farming, something to that effect. In our brief, we noted Black's Law Dictionary. There's several definitions, but the theme there is commercial being an enterprise, being a for-profit business. If you, and this is all in the record, Your Honors, if you look at the financials of the Wilmoths, the first year that they made any money, any revenue at all reported on the taxes was in 2018. In 2019, the most recent year that we have, the farm activities made $6,718.10 at the time of trial. The business, Wilmoth Family Properties, that operates Cedar Pond Farms, made $53,965.80 as reported on their tax return. So we would argue that this is no commercial farm. It is a farm, not a commercial farm. But regardless, if it was, these activities are not recreational and they're not entertainment as defined by our agricultural statutes. They're not recreational because there's nothing recreational about a wedding. There's nothing recreational about a fraternity party or a gender reveal party or a political rally. The Supreme Court touched on, well, while we don't have a definition of recreational in the statute, the Supreme Court touched on that in Maple Lane Farms and said that they noted that in that case, an expert witness from, I believe, the University of Tennessee testified that, recreation needs to be active, not passive. Leaves us with entertainment, conducted in conjunction with, but secondary to, the commercial production of farm product. In the very few cases that we have, and in the legislative history, the in conjunction with, but secondary to, I think is the biggest, that's the biggest issue here. In the committee meetings, which this is in the legislative history attached or included in the record, Representative Doss, and this is a quote from her, they were talking about this definition of entertainment. And she said, so it's for farmers that are really real farmers doing a secondary income, so it's not going to affect. And second quote is that this is going to be real farmers doing real enterprise on their farms. The whole idea behind allowing entertainment to be included in the definition of agriculture is to allow farmers to supplement their income. Everybody knows that farming is a bit of an up and down enterprise. So the idea here was to allow those farmers to supplement their income.
Council, what farming operations were being conducted on this property?
Yes, Your Honor. At the time of trial, there were 24 egg-laying chickens. There were 7 head of cattle and a dozen or so acres, I believe, of fescue hay that was being grown. Again, as of trial, Mr. Wilmoth had sold 5 head of cattle on one day, and that's it. The 24 egg-laying chickens supply eggs to another one of Mr. Wilmoth's businesses. It's a gelato business, and he uses those eggs in the batter for the gelato. The hay is baled, and at one point it was split between the gentleman that baled it and Mr. Wilmoth. I believe he may have sold some bales since then, but that's the agriculture activity going on the property, Your Honor. Again, the question is whether or not all these folks showing up for a wedding, 400 people, whether that is in conjunction with but secondary to commercial farming. We argue it's not. If you look to the legislative history again, they give examples of what this would be. It would be strawberry farmers holding strawberry festivals, corn farmers having a corn maze, and pick your own pumpkin. Those are the types of entertainment activities that the General Assembly talked about in these committee meetings, not these other things. And so the Right to Farm Act doesn't apply because this is not a private nuisance suit. Agritourism does not apply because we're not talking about.
Then the legislature amend that statute after that Maple Shore case and added in these events, these musical events.
Your Honor, the statute was amended to include the definition, this entertainment inclusion. And the committee was very concerned that, and that was in direct result of the Maple Lane Farms case that Your Honor pointed out. That expanded definition caused great concern with the General Assembly, and they took care not to allow this type of activity to take place. And
they didn't specifically exclude wedding venues, so did they?
It did not specifically exclude, Your Honor, but the Tennessee Department of Agriculture's General Counsel spoke and actually said, and her quotes included in the brief, Your Honor, but she essentially said, if we're talking about a piece of property in a rural area and the main event or the main activity, if you will, that's going on that is a commercial wedding, then that's not in conjunction with the secondary to commercial production of farm products.
Okay. You have your rebuttal.
Thank you, Your Honor.
Yes, sir, Mr. Mullins.
Thank you, Your Honor. If it pleases the court, I'm Ben Mullins. I'm with the Knox County Bar. I represent the appellees, Sean and Priscilla Wilmoth and Cedar Pond Farms. Your Honor, Mr. Little is correct. The zoning ordinance that applies in this case is an R1 residential zoning. That, as Your Honor will recall, is the same zoning that applied to the Maple Lane Shore case. There is a specific statute in Title 13 of the Tennessee Code Annotated, which is the title that is the enabling statutes for all zoning ordinances that specifically excludes a municipality's zoning power, their exercise of their zoning power against agricultural activities. So the question then becomes, and has Judge Davies in this case very methodically went through his analysis. The first question is whether or not this is a commercial farm, whether it commercially produces farm products. And we stipulated to most of the facts, and most of the testimony was Mr. Wilmoth going through his agricultural activities. Yes, Mr. Wilmoth has other jobs. He is a real estate agent. He does own a separate restaurant under a different corporate entity, which is a separate legal entity altogether. But he is a farmer. He resides on the property. He spends, the testimony was, uncontroverted testimony was, he spends 80% of his endeavors working his farm, keeping up with the fields, keeping up with his cattle, keeping up with his eggs. They have an egg washing facility on site. The 24 hen-laying eggs produce 600 to 700 eggs per month. He does sell them to his restaurant.
That's a lot of eggs for 24 chickens, isn't it?
That was what the testimony was, Your Honor. I'm not a chicken farmer, but that was the testimony. They produce 750 bales in 2019, where he grossed $5 a bale. He is in the greenbelt status. He has greenbelt status for his tax exempt. He obtained grants through the USDA for his fencing. He went through an extensive testimony on how he rotates the fields between grazing his cattle, which he is selling now, versus the fescue that can be produced for hay bales. He talked about switching from round bales to square bales, as that was more profitable from a farming operation. So the uncontroverted testimony was he is commercially producing farm products. Now, I haven't met a farmer yet that showed income on their taxes, or very much income. That's the nature of farming, and that is true here too. But the testimony as of November of 2019 was that their farm income was almost $7,000. Now, Mr. Little didn't point out there's a little bit of a hedging. He mentioned the total income was $57,000. That included the $7,000 in farm income. It also included about $20,000 in Airbnb income. That is not at issue. Jefferson County does not regulate the Airbnb. The wedding venue income, it was in 2019, $28,375. So the wedding venue did make more money than the commercial production. But
explain this sweat equity concept. What does that actually mean?
The sweat equity concept is, one, you can't have a bright line rule on this type of analysis that if you make more money on an event than you do on your farm production, your commercial production of farm products, then automatically it's not in conjunction with, but secondary to. That would open a whole can of worms with regard not only to the agritourism and being able to allow farmers to supplement their income, but also towards their liability protections with regard to nuisances and liabilities. If you had a bad crop, you had a blight, you just didn't make money that year for one reason or another on your corn or your pumpkins, then would you lose your liability protection because you had a wedding that made $50,000?
So you make more money, although you may make more money on the wedding venue and so forth, but yet you're putting in more time and more work into the farming activity, even though
every day at 5 a.m. he's getting up and feeding his chicken, he's feeding his cattle, he has to maintain his fences. You know, Mr. Little talked about.
So does that balance off then? Is that something that has to be looked at to balance it off, or what?
As both Ms. Denton, the U.S. Department of Agriculture attorney that testified at the Senate hearings, and Judge Davies pointed out, it is a case-by-case basis. And Judge Davies' opinion said, as of the day of trial, he feels when you look at all the effort that goes into commercially producing the farm products versus the effort of 5 weddings, they had 5 weddings in 2019. They don't set the weddings up, they just make the space available, and then the people who come in do everything else. The 400 parking spaces is an unmarked field. The seating are folding chairs that are available. It's not like they have this already set up. They do have a large barn that can be used for storing hay and also being used for events. But these have dual purposes, which are designed to feed into what the modern concept of agriculture is, and that is allowing the policy of the state of Tennessee, allowing farmers to supplement their income. But yes, most of your time he's spent trying to make sure his cattle are okay, his chickens are okay, the fences are maintained, everything is irrigated properly, his fields are rotated, and that testimony is in the record. And Judge Davies, as the trier of fact, was sitting there judging the credibility of Mr. Wilmoth's testimony, subject to Jefferson County's cross-examination. And at the end of that, he found that under, when you look at the totality of the circumstances, money is a factor. You can't ignore money, but it can't be the only factor. You have to look at the total picture, and the total picture is how much of your resources are you dedicating towards commercially producing farm products. And that's what this judge did. Circumstances could change. Right now, they're having an average of 7 weddings a year, as the record would reveal, 5 in 2019. When you look at the legislative history, that feeds into exactly what Ms. Denton testified to. She said, if you have one or two weddings every weekend throughout the year, then that's the main event. But if you have a beautiful spot and you have a couple of weddings here and there, that's secondary too, and it is a case-by-case basis. It could be that Mr. Wilmoth abandons his farmings and just continues to do the wedding event. At that time, they no longer would be entitled to the protections of Tennessee Code Annotated 13-7-114, which prohibits the application of a zoning authority's power over agricultural activities, because at that time they would not be doing agricultural activities. Now, there is a question about whether or not this fits within the recreation aspect of the definition of agriculture, or it fits within the entertainment aspect of agriculture. As this court will recall, when it heard the Maple Lane Farms case, there were two definitions of agriculture.
I think I wrote the opinion on that.
You did write that opinion, Your Honor. You did. And there were two definitions of agriculture. One that applied to the Right to Farming Act included the definition of entertainment. And we weren't talking about weddings and Maple Lane Farms. We were talking about concerts and helicopter rides and things like that. But it was a pretty big event every fall for the farm. The general definition found in Chapter 1 of the code did not include entertainment. And the Supreme Court said, well, the legislature must have known what they were doing by including entertainment in one definition and not including it in another. And so the entertainment definition applies to the right to farm, but it does not apply to the zoning issue. So Blount County could exercise its zoning, and so that was one of the holdings of the Supreme Court in Maple Lane Farms. And of course, the legislature then went back and corrected that mistake, corrected that oversight to make those two definitions congruous. And so now it is clear they intend that entertainment activities, educational activities, and recreational activities be included in the definition of agriculture. So what are weddings? We only have one reference in the 2014 hearing where they were amending the statute to include entertainment in the general definition of agriculture. There was a question about weddings, and so it came up. So there is a presumption that they intended to include weddings in the entertainment bucket of this definition. And that's what Judge Davies held. I think that requires a little bit more review, though, because if you look at even in the opinion that you authored, Your Honor, on Maple Lane Farms, there was a conversation about and testimony about something recreational being something that is active. You're actively participating in it, versus something that's entertainment being something that you are relying upon a third party to provide entertainment. And what the real complaint is with the wedding isn't the ceremony where two people join in holy matrimony. It's the revelry that takes place afterwards. It's the dancing, it's having fun, but there's a community. These people are connected communally. They're all invited to this wedding. It's not, 100 random people going to see a concert, or 100,000 Neyland Stadium going to see Garth Brooks. So I do think that this court could hold that weddings and these types of gender reveal parties, bar mitzvahs, these types of events that do occur occasionally on Cedar Pond Farms would fit within the definition of recreation. And that's important in the analysis of the statute, Your Honor, because the definition of recreation does not include this calculus that the recreation has to be in conjunction with, but secondary to, the commercial production of farm products. That calculus only is found in the provision of the statute that applies to entertainment. So if it is recreation, it doesn't matter whether the income is different. It doesn't matter with the sweat equity approach. You don't have to get into that level of detail. It is included in the definition in and of itself. But as the court in this case, Judge Davies did in this case, he went to the entertainment and looked at all the facts, all the stipulated facts, all the testimony, the credibility of the parties that were testifying, asked questions about the farming activities, and all this is in the record, and Mr. Wilmoth's entire testimony, of course, is in the record, and you can go back and look at exactly what he testified to as his sweat equity consisted of. But he looked at that and said, it's clear that the majority of the resources, the majority of the effort, the majority of the time involved in this operation is commercial production of farm products. Weddings keep them afloat, yes. They make more money in weddings, yes. That can't be completely ignored, but it also can't be a bright line rule. And I think that if it if the definition of weddings fits within the entertainment bucket, I believe that is the proper analysis. It's case by case. There's an argument, Mr. Little alluded to it earlier in his presentation. There's an argument if they filed this lawsuit earlier and the lawsuit was tried earlier, there might have been a different result because the facts may have been different. But at the time this case was tried and where we sit with the record before the court, there was clearly a vast majority of the efforts dedicated to commercial production of farm products. An average of 7 weddings a year, that's that's about half a wedding a month. So that's what the trial court did in this case. He looked at the entire history of the property, and they purchased the property with the intent to convert it to a farm. It used to be a farm. There were some existing farm sheds and farm buildings on the property when they built it, and then they actually built some things on old foundations of an old dairy farm. And again, that is in the record. That is Mr. Wilmoth's testimony. It's uncontroverted at this stage. So in all, Your Honor, we think this is a case-by-case analysis that Judge Davies properly sat in his position as a trier of fact, weighing the credibility of the parties, and looked at all the facts, considered everything, and made the right decision that as of 2019, when this case was heard, that this was a commercial farm and that the entertainment activities were secondary to the commercial production of farm products. And with that, I'll yield the rest of my time.
Is there any questions by the other judges? Thank you very much, sir.
Thank you.
Yes, sir, Mr. Little. You have your rebuttal.
Thank you, Your Honor. So to touch on the recreation portion first, although this is a de novo review, Judge Davies did not find that these activities are recreation. I do understand that issue is before the court, though. Speaking to that, additionally, some of the other activities that take place are things like corporate board meetings and the like. That my argument is that would be a stretch to include recreation or include that in the definition of recreation. Admittedly, there's not much guidance in the statute here as far as that definition. But when I think of recreation, I don't think of 400 vehicles coming, and in the case of corporate board meetings, folks working and being on the clock, so to speak. Turning to the entertainment definition, and just to touch on what Mr. Mullins said, so the income portion, I would argue, is the only component, and that's reflected in Representative Doss's quote that we included in our brief, where she says, real farmers really farming doing a secondary income. So I would posit, and there's other language in the legislative history as well. The focus here was helping these farmers supplement their income, not supplementing their time or taking away time from farming or their sweat equity approach. It was all about income. That was the concern. So the sweat.
But aren't we very much aware that a farmer can work as hard as he wants to 7 days a week and still sometimes don't make much of an income?
Yes, Your Honor, absolutely. The other side of the concern of the General Assembly here was what they called a financial motive. They were concerned that you could be doing a minimal level of farming and take advantage of this newly expanded definition in Title I and exceed your not exceed, but use this essentially as a commercial enterprise under the guise of it being a farm.
Wouldn't that be on a case-by-case basis? That's the reason it has to be looked at that way?
It is a case-by-case basis, Your Honor. Mr. Mullins, I believe, said that as well, and that is correct. That's reflected in the legislative history. But Your Honor, it was clear from my reading of that Your Honor's correct. Farmers' income is highly dependent on a lot of uncontrollables. And so the idea here is to allow them to make income from other sources. But there was that great concern that this would be used in the inverse. As long as you've got some de minimis level of farming going, then presumably you can do anything on the property, regardless of the zoning ordinances. And just real quick before my time expires, if we do go to the testimony, I thought it was poignant. Mr. Wilmoth testified. He does not consider himself a farmer. He doesn't tell people he's a farmer, and he does not consider himself a farmer. He's a businessman. He's got other entities than just the Wilmoth family properties. And I say good for him. It's just that in this case, the farming is clearly secondary to all of these other commercial activities. Just to clarify as well, this is not a private nuisance suit, so the Right to Farm Act does not apply. I wanted to touch on that, make that clear. But with that, I'll yield the rest of my time if the court has any questions.
I don't hear any. Thank you both very much.
Thank you.
We will take this case under advisement and thoroughly review it, and you will get an opinion and our decision within a reasonable period of time. Thank you again. You may be excused.
Thank you.
This honorable court is now adjourned.